You're you're still are muted, Miss Perry. You just have to go. Excellent. Now you did it. Very good. All right, everyone. And whenever you proceed, you may proceed, Miss Perry. And before we begin, how much time do you wish for rebuttal?
5 minutes, please, Your Honor.
Very good, ma'am. You may proceed.
Good morning, Your Honors. May it please the court. My name is Allison Perry, and I represent the appellant, the former husband, Mr. Joseph Arthur Wendell. 5 minutes, please, for rebuttal. There are two main issues before this court this morning. I'm sorry, my dog decided to start barking. Lucy. The first issue has to do with the husband's income determination when determining his child support obligation. There are three sub-issues when it comes to the husband's income determination. The first issue I'd like to address is the fact that the husband did a motion for rehearing of the original final judgment. In that motion for rehearing, he pointed out that one of the things he pointed out was that his Schedule C business expenses were not taken into account when determining his business income. And the court granted the rehearing on that specific issue. And at the rehearing, the court issued an amended final judgment. And at the first time this amended final judgment, all of a sudden, the husband's personal taxes that were never at issue before and was not before the court were all of a sudden taken out of his net income. Were added back in, actually. I'm sorry.
Can I tell you, Ms. Perry, I know what you've indicated, that you take issue with that, but isn't a trial judge, especially when they're sitting in the family law division, one of the things that they have to determine for child support, what is the income? What is that individual's income? Right. So they have to look at everything that that individual is making. So I guess my question to you, why should he get a deduction for something that he's not paying anyway?
Well, first of all, he is paying it. One of the issues before the court that the parties were bringing before the court was, Your Honor, how are we going to pay these taxes? This was the original, in the original final judgment, on page, it's on page 3454 of the record. The court in the original final judgment said, you've brought to me, you haven't paid your taxes since 2013. So the parties hadn't filed them for 2013, 14, 15, and 16. And it asked the court, how are we supposed to pay these taxes? And on that page of the record, the court in the original final judgment says, this is the way both of you are to pay the taxes. Married filing separately, married filing together. You take this number of the children as dependents, file head of household. So you have to understand, not only was he not paying his taxes, the wife wasn't paying her taxes. So if
Perry, this is a little different. As I understand what happened on rehearing, it's not a question of filing the taxes. It's a question of whether he was doing the withholdings, and he admitted at the rehearing motion that he's not doing the withholding, and as a consequence, he has greater income than his financial affidavit would reflect.
It's my understanding it wasn't time, the time to pay these taxes, it wasn't the time yet. Remember, the hearing was not noticed. That's why there's a due process problem here, because he had no idea that taxes were going to be at issue at the rehearing, because there was no notice that taxes were going to be discussed at the rehearing, because the only slim issue at issue was his Schedule C business taxes. That's all that was supposed to be discussed at the rehearing.
But this wasn't raised sua sponte by the judge. It's your client, as I understand it, brought up the issue about failure to withhold.
No, this was brought up sua sponte by the judge.
I guess to follow up, Ms. Bear, with Judge LaRosa's questioning, the judge recognized that part of the judge's obligation is to make sure that whatever the amount of income is, to apply the appropriate deductions and then set forth a schedule what would be the amount. And so in this case, based on your client's statement, based on your client's admissions that he did not do the necessary withholding, based on that, the court is obligated to, in order to fashion the amount of child support based on whatever income that your client has. So the fact that it wasn't just out of the blue where the judge is surmising or speculating that your client is not taking deduction, that's in the record. And so that's the issue that I have, that, you know, child support obligations are made based on the income that you have. And what the judge did, looked at the appropriate income and made the appropriate calculations.
But there is not, this income is not available to pay child support, because he does have to pay taxes. Unless he has found some loophole, he is going to pay taxes or he's going to end up in jail. And the purpose of establishing child support is not to encourage people not to pay their taxes. I mean, this man has to pay his taxes.
Well, let me ask you this question, Ms. Perry. Up until the time that the final judgment or the actual order was entered by the trial court, your client has not taken the necessary withholding. Is that correct?
No, he actually has. He's withheld. He hasn't. The payments were not due at the time of the hearing. That was my understanding.
All right.
So now the bottom line is 61.30 requires, it says shall. And this wasn't an issue. The wife, like herself, she did not have an issue with the husband taking the federal deductions and the Medicare and the FICA deductions. She did not, she understood that he has to pay his taxes, like any citizen has to pay their taxes. So she wasn't asking for this relief at all.
Well, if I may, but with child support, as you know, parties cannot waive child support. Child support is unique to the actual individual. So the wife does not need to bring that issue. It does not need to be raised. And it goes back to my initial question, what is the judge's obligation? The judge's obligation is to determine, we're dealing with children, we're dealing with the best interests of the children, we're dealing with what do the children need in terms of support. And that's why the statute is very clear. And based on that, what is the income are we dealing with? And that's the pie that the judge looks at, is the income. You don't need, the wife doesn't need to raise that to the judge, for the judge to consider it.
The statute is clear, and 61.3A says you shall deduct the federal taxes. It says shall, it doesn't say may. And the fact that these, you know, to set up a child support obligation that the husband is unable to pay, he has to either pay his child support or his taxes. That is not in the best interest of the children. The best interest of the children is to establish a child support amount that the parent can pay and that is accurate. Now, these parties came to the court to establish, hey, how are we going to pay all these taxes we haven't for all these years? So he knew there were tax issues. The tax issues were dealt with at the trial. Then at rehearing, all of a sudden, with no notice to the husband, and just because there's a motion for rehearing, it was on a limited issue, and the limited issue had to do with business expenses, Schedule C business expenses. That didn't open up that did not give him notice and open up his income to be able to change it and all of a sudden add back his taxes. He had no idea this was going to happen. He didn't, have an expert there to help him or get a chance to even address it, because he didn't know until he got the amended final judgment that the judge was contemplating doing this. So, you have to have notice. And the main thing is, this is not in the children's best interest to establish a child support guideline that doesn't take into account their parents' tax obligation. And it's also inequitable because the wife was not treated the same way. The court was aware that the wife also was not paying her taxes, yet it did not add back in her taxes in determining her child support obligation, because she, of course, also has a child support obligation. So that's a due process issue, and that is not following the statute, the requirement under 61.30 that taxes shall be taken into account. I'd like to move on and address the proportional treatment that the court gave to the business deductions. That's a second issue of the income. When the trial court did allow for the rehearing, the court said, okay, you're right. I'm supposed to give, this is how you figure out business income. These are your Schedule C expenses, which included stuff like healthcare. His healthcare was $527 a month. That actually,
and those are all fixed costs, correct?
yes, they're all
regardless of how much income is generated.
Correct. And so these costs were over $4,000 a month. And the court said, well, Lamar Industries, the industry that you're self-employed in, used to make $10,000 a month. And now you're only making $3,500 a month. So proportionally, you've reduced your income by 65%. So I'm going to reduce what you're going to be able to deduct by 65% proportionally. So instead of having a negative income for Lamar Industries, you're going to have a positive income. There's no support for this. There's a formula to determine business income. It is income brought in minus the necessary income. It's ordinary and necessary to produce income. So although the husband had over $6,000 of expenses, the court only allowed $4,600 of it. And there's just no support for that. There's no support in the law. The law states in the statute exactly what the net income is from business expenses, but it only allowed 35%. So allowing a full amount of that, his income is going to go down by, another like $3,000 some dollars a month, because all of his expenses, there's no support for allowing this proportional reduction. Do you have any questions on that issue? No. Okay, the third issue is it was an abuse of discretion for the court not to consider or reopen the evidence when it found out that since the time of the final judgment and before motion for rehearing or reopen the evidence had run, that the husband had lost his $150,000 per year job. Now, there's a case out of the 3rd District called Byrne v. Byrne, and that's cited on page 41 of my brief. That's at 128 Southern 3rd 2. And that case stands for it was an abuse of discretion not to reopen the evidence when the court found out, was alerted that during the time period, they did a motion to reopen the evidence during the motion for rehearing period, stating that the wife was earning $7,000 less per year. And the court said it was an abuse of discretion not to reopen the evidence because it impacted the wife's ability to pay alimony, and section 61.80 contains mandatory language that the court must consider in making an alimony award. Likewise, what's different in that case, and I will say there is a distinguishing factor, in that case, the husband in that case agreed that the evidence should be reopened. But the logic is the same, since 61.30 requires the court to consider what you have for income. The court was going to have to recalculate, since it granted the motion for rehearing, it was going to have to recalculate the husband's and the wife's child support obligations anyway, and losing $12,500 a month in income is clearly material and should have been addressed. There's no reason. The court said, no, you need to do a modification action. I say this is an abuse of discretion, that the court should have dealt with this during the rehearing, which was held in April. It was held several months later.
Wasn't there,
Could we find, could we uphold?
Before Judge LaRose asks, you're getting close. You're
There-
about
there appeared-
in your rebuttal time. Go ahead, Judge
There
LaRose.
appeared to be some conflict as to whether or not, even if his employment ended, there was still some factual disputes about whether that income was going to continue.
That dispute only lasted if it was going to continue. The termination letter was basically saying, you need to give us this within this amount of time, or this is your last paycheck, basically. So it was a limited period, which clearly would have and did filled itself out way prior to when the rehearing was held. So it would have been in everyone's best interest, especially the children, because what you've done is you've set up this child support amount that this man is supposed to pay, that there's no ability to pay it. He has been slammed with having these taxes added back on. He's been, $12,500 a month of income that he no longer earns. And what's happening, and he's been ordered to pay more child support than he even brings in a month, which is just.
Ms. Perry, I know you asked for rebuttal time.
Okay.
If you like to, you have 4 minutes.
I'll stop and let
All right.
and wait for the rebuttal. Thank you.
Very good. And you have 4 minutes for rebuttal. Thank you, ma'am.
Thank you.
And I'm going to ask you, Ms. Perry, to mute your microphone, and then Mr. Brush, for you to unmute your microphone whenever you're ready, sir. Excellent. All right, Mr. Brush, you may proceed, sir.
May it please the court, I'm Robert Brush representing Stephanie Wendell. I'm going to take these in reverse order. And the last one that the appellant is claiming is that the court abused his discretion in not granting a rehearing. And in fact, I think the questions from the court are right on point, and that is that when the original motion for rehearing was filed, the documentation that Mr. Wendell filed, he was represented by counsel then, suggested that there was a threat to stop the payments. And whether or not by the time the hearing was actually held, which I think was in May of 2018, what's happening here is Mr. Wendell has a claim for $178,000 of quote wages. He has a claim to forgive $150,000 in debt. He has a claim for a house worth maybe $300,000 or more in Cocoa Beach. And I think that Judge Tibbles did exactly the right thing by saying, look, file a petition for modification of the child support, because all those issues, including Mr. Wendell's ability to earn money, which he testified at trial, was he could earn up to $500,000 doing one of the various things he qualified for. He's highly qualified. He's a Naval Academy graduate. He's a CPA. And so I think Judge Tibbles made the right choice that all of this would have to be fleshed out, including how much of this money Mr. Wendell ultimately recovered in subsequent litigation against his employer. So, and that petition was filed by Mr. Wendell's attorneys, one of their last acts in August of 2018, shortly after the court's order came out on the rehearing. So as far as proving an abuse of discretion, this clearly does not rise to that level in what Judge Tibbles did. They have a sub issue there, and that is that the judge should have read the motion for rehearing as a motion to reopen the evidence. As we know, Mr. Wendell was pro se by the time of the hearing on rehearing. He did not hire a court reporter, so we don't have a transcript of what occurred, but I have no memory of anybody saying reopen the evidence, of that phrase being used, or even a discussion. The discussion was Mr. Wendell talking about his various business expenses, and through that, he opened the door. He opened the door for the judge to say, well, if you're talking about business expenses and income, then the court was going to talk about the amount of money he was not paying in taxes, and therefore found that as additional income to him. So as far as abuse of discretion on these points, there is absolutely no evidence that Judge Tibbles abuses discretion. The petition for modification is still sitting there, and we'll go back to at least the date of filing whenever those issues are heard. Now, as far as the complaint that the judge did not reopen the evidence given what was there, and again, Mr. Wendell was pro se by the time of the motion for rehearing, we cite the case of Corrigan versus Vargas. And if somebody submits false information, they are found to have unclean hands, and they can't complain when the court cannot make a specific calculation. Our brief goes in great detail the way in which Mr. Wendell has tried to obfuscate his actual income, his actual expenses. And again, he's a licensed CPA, but his business expenses seem wildly exaggerated. And yet he never produces sufficient actual documentation to show his complete income. Therefore, it's our position that he went to the motion for rehearing with unclean hands. However, the only evidence presented was Mr. Wendell's self-reported figures and his testimony regarding the child support. Another important case is Dioka versus Dioka. And it basically states that if a litigant fails to cooperate with the process by introducing evidence that would lead to accurate computation, the trial court can still make and state findings of necessary amounts. The litigant then has a burden to show a change in circumstances, which is what he would do in his petition for modification that he filed in August of 18. And then Dioka states that if the husband failed to present evidence to support deductions that he claims entitled to, he has forfeited his opportunity to do so. It is not the trial court's burden, as suggested in oral arguments, to maintain a schedule of federal income tax rates on the bench in order to calculate a litigant's tax deduction. So Mr. Wendell was given a motion for rehearing. Mr. Wendell was allowed to present his evidence. Mr. Wendell decided not to come with an expert, a CPA, an independent expert, and therefore, as the issue 2, the appellant cannot show abuse of discretion. As far as determining that the money that Mr. Wendell was not paying on taxes be included in income, I agree that was the obligation of the trial court to do that. And I read the child support statutes as saying when these are being paid, because it talks about looking at a person's status and how they file. So the judge was well within his discretion and in consistent with his obligations to find that the money not being paid for taxes was part of income. And
What about your colleague's argument that although that was added back into the husband's income, that was not added back into the former wife's income?
Well, by that point, they'd been separated since I think 14, and she's working for ADT, and she gets a W-2 at the end of the year. So as far as where she was working at that time, she was paying taxes since she separated from Mr. Wendell. So therefore, her income didn't have that added boost in it by her not paying the taxes. Issue 3 also talks about that the judge was wrong in not allowing Mr. Wendell to relocate with the 3 boys to Cocoa Beach. This family was ensconced in Tampa. Their boys were ensconced in Tampa, and they went to school in Tampa, and all their friends were there. And they were fairly social family. Miss Wendell becoming the president of Junior League at one point. The boys went to private schools, and there was no reason for the husband to move to Cocoa Beach other than just maliciousness. Had he stayed in Tampa, my client testified that she would have agreed to 50-50. So all he had to do was stay in Tampa, which, by the way, he worked there 2 or 3 days a week. So he drove across the state from Cocoa Beach to Tampa to do his work because a lot of his clients were in Tampa. But yet he wants to uproot the boys and take them to Cocoa Beach. So
if I may, Mr. Brush, I know you mentioned the term malicious. There's really nothing on the record to support that. As I hear and as I read the record, is that her client or the appellant basically thought it would be great to have the kids relocate there, that apparently the former wife's family is from there as well. So I just want to at least make sure there's nothing, at least that I read here, that it was done for any malicious purpose. And correct me if I'm wrong, but I don't believe that was in the record. Was it?
Well, her parents just so happened to live on Merritt Island, which might be where they were married, and that's a bridge or two away from Cocoa Beach. But Mr. Wendell was not going to be taking the children over to see their grandparents on a regular basis. I thought that Judge Tibbles did make a comment about maliciousness, and I'm not sure where that is.
No problem, sir. I could pull it up right here, Mr. Brush, so you may continue.
But given the fact that Mr. Wendell, after he moved to Cocoa Beach, spent a lot of time in Tampa, there didn't seem to be a good reason for it. So at either rate, there's plenty of facts in the record to say your request for relocation is denied. These 3 boys have a life in Tampa, and at this point, the oldest one was a teenager, and uprooting them to someplace else is not appropriate. The other criticism they have is they claim that Dr. Buffington, who has a doctorate in pharmacology and toxicology, they claim that he violated his licensure statute. I think it's chapter 465 of the Florida statutes, because he made a diagnosis. If you look at Dr. Buffington's testimony, he actually doesn't make a diagnosis. And they say he wasn't qualified. In the case they cite, the magistrate let the expert call in by phone, didn't qualify the expert, and didn't put the expert under oath. That case is not applicable to this. Dr. Buffington's qualifications to do what he does are found at record on, I believe it's 988 and 987, which are pages 890 and 891.
Mr. Brush, as I read the order, Judge Tibbles sort of downplayed Dr. Buffington's testimony. Am I correct? The judge's major criticism was it Dr. Paganez?
Prang.
His report really did not update to account for Mrs. Wendell's improvement of whatever diagnosis she had.
Correct. It was the husband's who came out, I thought, biased for the husband was Dr. Prang. And I thought the doctor, who's a psychologist, and he's in the business of being hired for these cases, I thought Dr. Prang was completely impeached at trial. And that's the testimony that Judge Tibbles didn't agree with. And Dr. Buffington doesn't diagnose, although he's capable under the DSM of diagnosing alcohol. What Dr. Buffington did was told the court how the PEth test works, because Dr. Prang misstated how the PEth test works. And basically the PEth test at this point simply tells us that in the last 3 or 4 weeks, somebody has consumed alcohol. Doesn't say how much, doesn't say what kind. And Dr. Prang totally misstated the science on the PEth test. In addition, Dr. Fernandez, after one visit, diagnosed Ms. Wendell with severe alcohol abuse disorder, but as to the 11 criteria in her records, only filled out 1. And Dr. Prang helps doctors diagnose alcohol abuse, Dr. Buffington helps physicians with alcohol abuse problems. He said those have to be documented. They weren't. And then Ms. Wendell went to 45 different urine tests where she was negative, had 2 later PEth tests where she was negative on any alcohol. Plus, in addition to Dr. Buffington's testimony, criticizing Dr. Prang, who I think was impeached, Jen Carlstadt, a friend of Miss Wendell's, testified that when she first started going through the divorce, that like many people, she was temporarily out of sorts and that she was drinking too much alcohol, but that they had conversations amongst other people and that she'd straighten herself out by the time of the trial. And trial was in, I believe, May of 17. So there was plenty of evidence, and other witnesses testified as well that Miss Wendell did not have a substance abuse problem, i.e. alcoholism, by the time of the trial. So I think that Judge Tibbles was well within his discretion. And I would say the majority of the evidence supported that Dr. Prang was not correct. And by the way, the husband's side decided not to call Dr. Fernandez, who allegedly diagnosed the alcohol disorder, by writing down only one of the 11 criteria. So it looks like the suggestion was made at trial that Miss Wendell had been thrown into this money-making machine of, well, you've got an alcohol problem, go see this person, now go see this person, and so on, when in fact she didn't. The problem wasn't documented. And the evidence was, by the time of trial, she didn't have a drinking problem. Therefore, given all that, Judge Tibble's decision that she wasn't an alcoholic, it wasn't interfering with her taking care of the 3 boys, it wasn't interfering with her going back to work and making it a very handsome salary, he was in his discretion to deny the relocation, as it was not in the children's best interest. Well, I believe that's all I have, unless there are any questions.
I don't believe there's any other questions. Thank you, Mr. Brush. Appreciate it.
All right.
And if I
Thank
can
you, Judge.
have you mute your microphone, and then Ms. Perry, if you could unmute yours, you have 4 minutes for rebuttal, ma'am. And actually, Ms. Perry, you're still muted. If you could, you're still muted. Just excellent. You got it.
Thank you.
You're welcome.
Thank you, Your Honor. Okay, so actually, Mr. Buffington has did do a diagnosis, and he, after it was objected to, his testimony was objected to twice, and he was voir dired. During voir dire, the husband's counsel inquired, with your PhD, you are someone who can professionally make DSM diagnoses? And Mr. Buffington responded, absolutely, the answer is yes. And said, I can do it absolutely under Florida 465. And this is incorrect. That statute specifically states that that individuals with the pharmacy degree cannot make a diagnosis. And that is in the brief.
But didn't he say that he could do it in conjunction with actual physicians? And
But he
maybe in
didn't
sort
do
of,
that.
but under, isn't there a statute that allows for a collaborative pharmacy practice?
But he didn't do that. In fact, what he did was he said that the doctor was wrong. He contradicted a doctor who was authorized, that does have the capacity. And this,
well, what he did is he said that the doctor didn't follow the normal procedure to make the determination.
That was just conjunction. He was saying that this self-reported test, there's a test that has 11 factors on it. And it was the wife self-reported the issues that she thought she had with alcoholism. And if you look at Dr. Prang's report, which, by the way, Dr. Prang was a joint specialist. He was a joint expert that the parties agreed would do the recommendation on whether or not the children should relocate. And when it didn't turn out the way the wife wanted, she objected, and she got Mr. Buffington to criticize Dr. Prang's report. But Dr. Prang's report is very revealing. Besides the alcohol issues, there are personality disorders. And these personality disorders prevent her from having the capacity to put the children's interests first. And the big problem with this whole case, and it's very clear from the final judgment, is that this judge did not like Mr. Wendell. I mean, there's clearly a bias. He says that the husband had a scorched earth policy when it came to doing this case because he glared at the man who was having, that had an affair with his wife while he was married to him, married to the husband, and, basically destroyed the family. And you can read it throughout the whole final judgment. But the bottom line is that Mr. Buffington did not have the qualifications. The judge did rely on Mr. Buffington's testimony heavily. And besides that, there's no competent substantial evidence to support the judge's finding that it's in the children's best interest not to relocate, because they have a parent that has personality disorder that doesn't have the capacity to put their interests first. And then we have a parent. Go ahead.
And on that note, Ms. Perry, you're getting closer to your 4 minutes. So
okay. Well, clearly we've got an income determination that has this proportional reduction that has no support in law, that must be reversed, because business income is determined. It's a mathematical equation that has no room for this proportional treatment. And the tax issue, it's not equitable, and it's not fair to burden this husband, this father, with a child support obligation that exceeds his actual income. It's just
very good. Very good.
Okay. Thank you, Your Honors.
All right. Well, thank you both at this time, and appreciate both your arguments. All right. We're going to give you the opportunity to sign off, and there'll be a brief delay till we get the next case.
Okay. Thank you.
Wonderful.